Mr. McDowell, professional regulation.
Thank you, Treasurer. I have a couple of matters to speak to. One matter for decision, and then Mr. Mercer is going to deal with the on-camera matter. So the report is at tab 9 of board books, beginning at page 545. The matter for decision is relating to short-term pro bono legal services. So Convocation's approval is sought for amendments to the rules of professional conduct respecting conflicts of interest relevant to pro bono, short-term pro bono legal services. The motion is at tab 9.1 at page 536. There's a red line version of the amendments, and I congratulate anyone who can actually follow the red line. It's at page 539. The clean version, tab 9.1.2, is at page 542. As the report explains, in 2010, amendments were made to the rules to provide a modified conflict of interest standard for lawyers participating in Pro Bono Ontario's, then known as Pro Bono Law Ontario's, court-based brief services program in the Superior Court or in small claims court. That has been, I would say, a roaring success, the program. And since 2010, the range of programming offered by Pro Bono Ontario has greatly expanded. The purpose of the amendment is to catch up with that expansion, to provide guidance in the rules that is more inclusive of the diverse range of Pro Bono Ontario's programming, but also to contemplate the possibility of similar programming offered by other providers, as long as the following criteria are met. First, the lawyer must be acting pro bono. Second, the legal advice or representation that's being provided by the lawyer to the client is being provided with the expectation by the lawyer and the client that the pro bono lawyer will not provide continuing legal advice or representation in the matter. A pro bono provider is defined as a pro bono or not-for-profit legal services provider that makes pro bono lawyers available to provide advice or representation to clients. The committee began its review of the rules in this area in 2015. There was a call for input. Importantly, the committee contacted General Counsel of the main Canadian chartered banks to ask for their comments on the suitability of a modified conflict of interest standard in the event that a pro bono lawyer from a law firm representing the bank were to assist a member of the public who is adverse in interest to the bank as part of their volunteer work, because that's one of the very frequent areas of collision with clients of Pro Bono Ontario. The responses received from the banks were very positive. 3 of the 5 major banks offered their support. A number of thoughtful comments received from the banks, and it is clear that the banking sector has a real commitment to corporate social responsibility and access to justice, as reflected in their approach to this problem. Now, with that explanation, I'm not going to walk through the text of the rule. Do I have a seconder for the motion?
Mr. Rosenthal.
All right.
Any questions, comments on this second time around?
The conference is no longer in lecture mode.
Any questions on the telephone? Hearing none, I'll put the matter to a vote. All in favor? Any opposed in the room? Anyone opposed on the telephone? Thank you, the motion is carried.
The conference is in lecture mode.
So very quickly, the 2 information items, the 2016 Lawyer Annual Report, the LAR, that pages 623 and following. There are new mandatory questions about lawyers holding deposits under condominium legislation which have been added to the LAR. The text of the questions at pages 621, 622. Lawyers will be required to indicate in the LAR if they received, held, or dispersed condominium deposits under Section 81 of the Condominium Act, 1998, which I have not committed to memory. They're also asked to declare that they complied with their obligations for the receipt, holding, and release of condominium deposits under the legislation. There are two other questions regarding the deposits. The Condominium Act permits lawyers who represent condominium developers to hold deposit money in trust. On some occasions, lawyers have released deposit monies in ways that appear to be contrary to the Act and which appear to have caused financial harm to members of the public. We believe that the questions on the law will enhance public protection. Lawyers who practice in this area will be reminded of their professional obligations when responding to their questions as part of the annual report. Further information from the answers to the questions will assist us at the Law Society in understanding the nature and scope of the risks posed to the public and how to address those risks. The other matter, if I've got my notes.
So just to be clear, there are going to be changes to the law. They don't require approval by convocation.
That's correct. And the other thing following on from Ms. Mandarin's discussion earlier this morning, there is a new format to the quarterly report. It's at page 588 of board books. For example, Ms. Mandarin and her division have attempted to consolidate on one page the outputs or work produced by the Professional Regulation Division. If you look at page 588 through 591, there is an effort to provide statistics to clarify what is coming into the division and how the division is disposing of this workload. And so, for example, one of the things that's set out there is there's a trend or a snapshot that shows that complaints against lawyers in private practice seem to be rising. Complaints against paralegals in private practice at the moment appear to be falling. Just a few other highlights. Back briefly to page 588, the number of issued notices of application continues to be consistent. Motions for interlocutory suspensions are increasing, which I think shows a responsiveness to the division staff to the request of convocation that the division act quickly and increasingly to suspend in appropriate circumstances. 589 tracks the number of complaints coming in, which appear to be consistent. Also consistent appear to be the types of allegations raised and the areas of legal practice they relate to. And it's broken out there. It's been a long morning, I won't go through it, but it's interesting to look at the correlation, size of firm, age of licensee, which is something that begins to trouble me a little bit, but it's something we're going to have to look at, I think, more carefully going forward, given that there is a concentration of complaints in lawyers, for example, practicing between 36 and 40 years. So with that, I think that covers off the information items. Happy to take any questions, or we can go in camera and deal with the disclosure matter.
We'll go in camera in a moment, but are there any questions for Mr.
The
McDowell?
conference is no longer in lecture mode.
Any questions on the phone for Mr. McDowell? Hearing none, thank you.